Hello everyone. This presentation deals with discharge of contract. When the rights and obligations created by a contract come to an end, the contract is discharged. It may be discharged by performance, by agreement or consent, by impossibility, by lapse of time, by operation of law, or by breach of contract. Discharge by performance. When the parties to a contract fulfill their obligations as per the terms of the contract is discharged. Each party is discharged when it performs its part of the contract. Performance may be actual, where the parties do what they have agreed to do under the contract. It may be attempted performance or tender, where one of the parties offers to perform its obligation but the other party refuses. Here, tender is equivalent to actual performance, except in the case of tender of money, where the party would not be discharged of his liability. Discharge by agreement. A contract is an agreement between parties, and therefore by agreement the parties may be discharged of the contract. The discharge may be express or implied. When the parties agree to substitute a new contract for the old one, or when they rescind or alter it, the original contract is discharged. Discharge by implied consent involves novation, where a new contract is substituted for the old one between the same parties or between new parties. It could be by alteration of the terms of the contract by mutual consent of the parties. The parties may decide to rescind the contract wherein all or some of the terms are cancelled. They may agree to accept lesser fulfillment of the promise, that is remission. Implied consent may also be in the form of waiver, where a party gives up a right under a contract. It may be by merger, where an inferior right of a party merges into a superior right, accruing to the same party under a new contract. For example, where A, who is on lease on a property of B, agrees to buy the property from B. Here, the rights available to A as a lessee will merge into his rights as an owner of the property. Discharge by impossibility of performance. Here, the contract contains a promise to perform an impossibility, and such a contract is void ab initio. This rule is based on two maxims. One, the law does not recognize what is impossible, and two, what is impossible does not create an obligation. Impossibility of performance may be pre-contractual, that is impossible at the time of entering into a contract, or post-contractual or supervening impossibility, that is arising subsequent to the formation of the contract. When the agreement is impossible to be performed at the time of entering into a contract and is known to the parties, it is void ab initio. Where it is unknown to both the parties, the contract is void on the ground of mutual mistake. Where it is known to the promisor at the time of making the contract and not known to the promisee has to compensate the promisee for the loss suffered due to non-performance of the promise. Regarding post-contractual or supervening impossibility, the general rule is that impossibility of performance is not an excuse for non-performance. But where it is caused because of circumstances which are not within the control of the parties are discharged from further performance of obligation arising under the contract. Supervening impossibility can be an excuse for non-performance of a contract when the subject matter of the contract is destroyed without any fault of the parties to the contract. For example, a music hall was lent by A to B for a series of concerts on certain days. The hall caught fire and was completely burnt down before the first concert took place. Here the contract is void because of the destruction of the subject matter without any fault of the parties. When a state of things forms the basis of the contract, the non-existence or non-occurrence of that particular state of things discharges the contract. For example, A and B agree to marry each other, but before the marriage could take place, B goes mad. The contract becomes void. When the contract depends on personal skill or qualification of a party, death or incapacity of that party discharges the contract. For example, A agrees to give a dance performance in the auditorium of B on a particular date. A day before the date, she suffers an accident because of which she became incapable of dancing for a few months. Here, she is discharged of the contract due to incapacity. Where subsequent to the formation of the contract, there is a change in law, or a person with statutory authority steps in so as to render the performance of the contract impossible, the contract is discharged. For example, A enters into a contract with B in January to supply certain goods to B in September. In June, by an act of parliament, the import of such goods is banned. The contract is discharged. When there is an outbreak of war, a contract entered into with an alien enemy is unlawful and cannot be performed, and hence the contract would be discharged. But supervening impossibility will not be an excuse if it is difficult to perform the contract. Just because there was higher expectation of profits by the parties which could not be realized due to hike in prices, the contract cannot be discharged. Where a contract could not be performed because of the default of a third person on whose work the promisor relied, it cannot be discharged. For example, A wholesale dealer of cloth, agreed to supply a certain type of cloth to B, a retailer. A placed order with C, the mill owner, for supply of cloth. Due to ill health, C could not supply the cloths to A on time, and hence A could not perform his part of contract with B. Here, B would be entitled to recover damages from A. Events such as strikes, lockouts, and civil disturbances do not discharge a contract unless the parties specifically agreed in this regard while making a contract. Where a contract is entered into for several objects, failure of one of them does not discharge the contract. In England, the rule in the beginning was that a man was bound to perform the obligation undertaken under a contract, even where the performance becomes impossible subsequently. This rule was laid down in Paradigm versus Jane. In order to mitigate the harshness of this rule, the implied term theory was evolved, according to which there is an implied condition in every contract that the parties can be excused when the performance becomes impossible without their default. This rule led to the doctrine of frustration, which is similar to the concept of supervening impossibility. The doctrine of frustration comes into play when the object of the contract becomes impossible to perform due to circumstances beyond the foresight and control of the parties. In India, the law relating to the doctrine of frustration is contained in Section 56 of the Contract Act. The impossibility contemplated under Section 56 is not confined to something not humanly possible. When the performance of a contract becomes impracticable or useless, it has to be held that the performance of the contract has become impossible. But under Section 56, the supervening impossibility has to be such as to take away the basis of the contract. It should strike at the root of the contract. What are the effects of supervening impossibility? When the performance of the contract becomes impossible or unlawful subsequent to its formation, the contract becomes void. Where the promisor knew but the promisee did not know that the performance of the contract is impossible, the promisor has to compensate the promisee for the loss suffered by him due to non-performance. When an agreement or contract is void, any person receiving any benefit under such agreement has to restore or compensate the person from whom the benefit is received. Coming to discharge by lapse of time, the Limitation Act lays down that a contract has to be performed within the specified period called period of limitation. If it is not performed and promisee does not bring any action in a law court within the period of limitation, he will lose his remedy at law. Regarding discharge by operation of law, here the parties are discharged independently of their wishes by operation of law. Death of a party to a contract discharges a contract when it involves his personal skills. Otherwise, the rights and liabilities pass on to his legal representatives. When a party to a contract is declared insolvent, he will be discharged from all liabilities incurred prior to being declared insolvent. A contract may be discharged by merger of rights. When the terms of a written agreement are altered without authority, the contract can be discharged. Where the rights and liabilities are vested in the same person, the contract is discharged. For example, A takes a house on lease from B, who is a relative of A. Subsequently, due to succession, A gets B's house as his share of the property. A is no longer a lessee as he becomes an owner of the house, and the contract between A and B is discharged. Finally, a contract may be discharged by breach of contract. When a party breaches his obligation under a contract, a breach of contract occurs. Breach of contract may be actual or anticipatory. It is actual when at the time when the performance is due, one of the parties fails or refuses to perform his obligation under the contract, or during performance, one party fails or refuses to perform his obligation under the contract. Here, the party not in breach can sue for breach of contract. Anticipatory breach takes place when a party to the contract declares his intention of not performing the contract. It may be expressly made or implied by doing an act which makes his performance impossible. The promisee can treat the contract as discharged and he need not perform his part of the contract. He can sue the promisor immediately for breach of contract or wait till the time the act was to be done. Anticipatory breach does not automatically discharge the contract. The promisee is discharged and he is entitled to sue for breach. If the promisee refuses to accept the repudiation of the promisor and treats the contract as existing, the promisor can perform the contract at the time when the performance is due, and the promisee has to accept it. While the contract is alive, if any event happens which discharges the contract automatically, the promisor can take the advantage of discharge and the promisee will lose his right to damages. Regarding measure of damages in anticipatory breach, the amount of damages will be measured by the difference between the price prevailing on the date of breach and the contract price. If the contract is kept alive till the date of performance of the contract, the measure of damages will be the difference between the price on the date of performance and the contract price. This in brief is about the rules pertaining to the discharge of contracts. Thank you.